ever pondered over the question of how far your privacy rights extend under the Fourth Amendment? You see, the Fourth Amendment is a cornerstone of our legal system, designed to safeguard our privacy rights. Yet the interpretation of this amendment can be a complex matter, varying significantly from case to case and context to context. But what happens when this interpretation challenges our traditional understanding of privacy? As we delve into the Hester v. United States case, you will see a unique interpretation of the Fourth Amendment. In the year 1924, the case of Hester v. United States altered the understanding of the Fourth Amendment. The case involves William Hester, a man from the rural areas of Mississippi. Federal agents, suspecting Hester of illegally distilling spirits, ventured onto his property without a warrant. They found a hidden path leading to a moonshine operation, complete with barrels of mash and a still. The agents didn't knock on Hester's door or announce their presence. They simply entered his property, discovered the evidence, and arrested him. Hester's defense argued that the search violated his Fourth Amendment rights, which protect against unreasonable searches and seizures. The argument was that his property, including the open fields, should be considered part of his persons, houses, papers, and effects, as stated in the amendment. However, the Supreme Court saw things differently. They ruled in favor of the United States, saying that the Fourth Amendment protections do not extend to open fields. The court reasoned that open fields are not places where a person has a reasonable expectation of privacy. The justices wrote, "The special protection accorded by the Fourth Amendment to the people in their persons, houses, papers, and effects is not extended to the open fields." This decision was based on the principle that what a person knowingly exposes to the public, even in their own home or office, is not subject to Fourth Amendment protection. The court stated that the prohibition of the Fourth Amendment is against all unreasonable searches and seizures, and it is not abstractly considered unreasonable for officers to search without a warrant. The decision in Hester v. United States was a clear departure from previous interpretations of the Fourth Amendment. It indicated that the government could, under certain circumstances, invade a person's property without a warrant, sparking a significant debate about the limits of privacy rights. This case led to what we now know as the Open Fields Doctrine. The Open Fields Doctrine, a term coined from this case, has been the subject of many legal debates. The doctrine, in essence, provides that the Fourth Amendment protections do not extend to open fields. Now you might be wondering, what does open fields mean? Well, it refers to unoccupied or undeveloped areas outside of the home. It could be an open pasture, a wooded area, or even a vacant lot. This doctrine is based on the premise that an individual cannot reasonably expect privacy in an open field, even if it's private property. It's worth noting that this doesn't mean law enforcement can just waltz onto your private property without a warrant. The area around your home, known as the curtilage, is still protected under the Fourth Amendment. However, the Open Fields Doctrine does allow law enforcement to search open fields without a warrant or probable cause. This has sparked debates about the balance between privacy rights and the needs of law enforcement. Critics argue that it infringes on privacy rights, while proponents claim it's a necessary tool for effective law enforcement. It's clear that the doctrine has a significant impact on our understanding of the Fourth Amendment. While the amendment protects our persons, houses, papers, and effects against unreasonable searches and seizures, the Open Fields Doctrine provides an exception to this rule. The Open Fields Doctrine is a clear example of how court decisions can shape our understanding of constitutional rights. So, what have we learned from the Hester v. United States case and the Open Fields Doctrine? Well, in the Hester case, we saw how the Supreme Court ruled that the Fourth Amendment does not protect open fields. It was established that law enforcement can enter and search a field without a warrant, as it falls outside the protections of persons, houses, papers, and effects. This led to the birth of the Open Fields Doctrine, a principle that allows police officers to search open fields without a warrant or probable cause. This doctrine has significantly impacted the interpretation of the Fourth Amendment, altering the landscape of privacy rights in America. It's important to note that these interpretations can shift over time, influenced by societal changes and fresh court rulings. This fluidity is what keeps our legal system alive and adaptive. Remember, the interpretation of our rights is a living, breathing concept that can change with time and court decisions.